Welcome to another episode of Chats Chat. Join Chad Chelius and me, Dax Castro, where each week we wax poetic about document accessibility topics, tips, and the struggle of remediation and compliance. So sit back, grab your favorite mug of whatever, and let's get started.
Welcome, everyone. Today's podcast is sponsored by Chax Training and Consulting. If you'd like your company announced during our podcast introduction, consider sponsoring our podcast transcript. My name is Chad Chelius. I'm an Adobe certified instructor, as well as Director of Training Solutions and Principal at Chax Training and Consulting.
And my name is Dax Castro. I'm Director of Media Productions here at Chax Training and Consulting. And Chad and I are both certified as accessible document specialists. And if you'd like your specialist certification as well, head on over to accessibilityassociation.org/certifications and learn all about the ADS certification that Chad and I actually helped write the test for by the International Association of Accessibility Professionals. Chad, how you doing, man?
Doing good.
So Chad and I are getting ready for CSUN coming up. We're really excited. We're getting ready to do a full day pre-conference workshop on document testing with NVDA, right, Chad?
Yep. Yeah, it's going to be great. I mean, we've done that as a webinar in the past, and we've retooled it for a full day conference workshop that we're going to be doing at CSUN this year. So it's going to be really cool. It's going to be really a lot of fun, I think.
I am so looking forward to it. And we're going to have our booth for the very first time. So for those of you who are listening, you know that Chad and I are, have jumped into the deep end of having our business now for, it's been almost 7 months, right, Chad?
Yeah, and, for sure.
And this is our first booth. So we're super excited. But even more excited than that, we are excited to have Jason Taylor, who is the Chief Innovations Officer at UsableNet here, to talk about their report. They do a report every year, the ADA Digital Accessibility Lawsuits Trends and Trends Report. Jason, welcome to the program.
Hey guys, thanks for having me.
No, absolutely. Jason, I love this report. It's interesting because not only the content, but, you and I have had a relationship through this report now for several years, actually. And for those of you who don't know, UsableNet, usually on LinkedIn is where I see it, sends out a link to a report that talks about a bunch of metrics that all kind of revolve around accessibility lawsuits. And Jason, I wanted to ask you, so, there's a lot of great stuff in this report. How do you guys go about collecting the data?
Yeah, so some context there, Dax, is, UsableNet as a company help a wide range of organizations essentially make sure that they're doing a great job of making accessible digital experiences, whether that's websites or apps. And part of that sort of landscape are these sort of private lawsuits that are essentially filed by plaintiffs that are typically blind, that essentially claim that websites and apps aren't accessible. And it's something that's been going on probably about 20 years, but it really picked up about 5 years ago when you and me actually started, going back and forth on this report. So our first report, and we can talk about how we actually took a lot of advice from Dax about improving that report from an accessibility point of view. But what we saw in 2017 is an explosion of cases, essentially going from around about 50 lawsuits to over 800 lawsuits in 2017. Right. To give that context, this year it's over 4,000. So it is, exponentially increasing every year. Essentially, this is one of the areas I think is really driving accessibility in the commercial space. Companies are taking accessibility more seriously because of these lawsuits. There's some doubts whether all these lawsuits are genuine lawsuits of people having struggles and bringing those lawsuits, but in general, they're important. They're important case law and they're an important part of our industry. So, on behalf of our clients, we try to track these lawsuits and look at trends, look to see the types of things that are being sued, the types of experiences, the types of issues that are being highlighted, so we can help clients make sure that they're creating great accessibility experiences and reducing their risk of getting lawsuits in this space.
Yeah, absolutely. It's interesting. I started my first delve into accessibility was right before California released AB 434. and
Right.
the governor said, everything's got to be accessible. And I was working on the high-speed rail program, and everybody was scrambling. Okay, next year, 2017, we got to make sure everything's accessible. What does that mean? And of course, I raised my hand, said I'll figure it out, and thus started my journey back then. What's interesting is that you mentioned that maybe not all of these are kind of official. Single person went to a website and decided that they couldn't get to information. I know there's a section here that is a bar graph that shows the number of cases filed in California, New York, and Florida. And I would say of the states in the United States, those are kind of the three hotbeds for legal activity, right? I mean, that's the typical areas. But what's interesting is the number of lawsuits in New York is almost double, and in some cases triple the amounts of lawsuits in other areas. And like you mentioned, I'm not sure that there's some super concentration of blind people or people experiencing barriers in New York, but we do know that the lawyers are definitely there. I did have a question though, about the overlays. Overlays is a big topic, and a lot of our listeners have mentioned overlays in our PDF accessibility Facebook group. Usually it's a new user comes onto the group. Right. They're like, hey, what do you know about overlays? And then of course, everybody jumps on top of them. And you guys have some great statistics on overlays, right?
Well, it's one of the factors that we're seeing inside of lawsuits. So, a quick methodology about how we collect that data. We actually download all of the ADA-related federal and state lawsuits.
Oh,
and
okay.
That includes physical and digital, and we have to separate them. They're actually not distinguished in the system any differently. So we download every docket, we read it, we determine whether the subject matter of claim was a website or an app, and then that becomes our data set, right?
Gotcha.
Part of that is recognizing that, as you said at the beginning, this is not 4,000 individuals. This is quite a focused, what at best you could probably call them an aggressive advocacy group, or a group of plaintiff firms which are sort of focused on this sort of weakness of companies not really addressing accessibility and knowing that they can actually bring lawsuits under the ADA on this space. So what we see by that is lots of similar types of structures to the claims. They're not like individually set together. They've got a sort of template to them.
Sure.
One of those template components is listing features of widgets. And for those people who are like not completely clear about overlays and widgets, what typically you're picturing in your head is you click on an icon and then a panel comes up and some additional features are there, like font size, color, and other types of controls. What websites are trying to do is say, hey, that's enough. That's us putting some money towards accessibility, and that's us showing that we're accessible. But actually, the lawsuits sort of say a different thing, which is the lawsuits actually include some of those features in the lawsuit, particularly for screen reader users.
Right.
And the other thing that we do is when someone gets sued, we go to the website and see whether it actually has a widget on.
Oh, okay.
So if it has a widget on,
you're doing a lot of due diligence there to make sure that that you're getting the right data, you're separating it the right way, and then going on to these websites. I know a lot of companies there, they say, what's the risk of excessive? They're like, usually it's new companies. They're like, look, this is a lot of work. It's a lot of extra work that we weren't doing before. What's the risk? Who's checking anyway? And in an actuality, not only are these lawyers checking, you guys are checking too.
Yeah.
Right?
Yeah, I mean, what we would say is, the hotbed, as you said, is essentially the lawsuits are coming out of New York and California, but that just means you have to do business there. It doesn't mean you have to be based there, right? So if you sell there, if you provide a service there, you're under the ability for someone to visit your website from there and determine that there's issues with that website and create a lawsuit. So first is, you're not protected by where you are. You're basically got to worry about where you're selling. And then the other thing is, we're seeing e-commerce, and maybe we can pull out some numbers there. E-commerce is big because, these guys are looking for, 4,000 lawsuits a year is 100 lawsuits a week. They need volume. They need to go to lots and lots of websites quickly. They need to determine whether they fit the criteria to sort of generate a claim and then file that claim. That's a significant business that they're doing. So they typically start with e-commerce because there's hundreds and hundreds of thousands of e-commerce sites to target. They're easy to visit. They're easy to do the similar types of tests because they've got similar functionality. It's easy to sort of put that experience into a template and then file suits. And that's why like e-commerce is probably one of the biggest areas that are targeted today.
For sure. Well, I found that there's a really interesting statistic in your report that almost 400, actually 391 of the Internet Retailer Top 500 list received an ADA-based digital lawsuit in the last 5 years.
Yep.
So that's a pretty prominent statistic. You know what I mean? And you know, I wanted to ask you, Jason, for the benefit of our listeners who, you know, we're primarily a document podcast, right?
Right.
But for the benefit of our listeners, when you talk about an overlay, and I think you described it very well, Dax, at CSUN last year, there was a gentleman who was giving out T-shirts that said your accessibility overlays are not accessible.
Yes.
Right. And so, like, could you pretty much say that overlays, period, dot, exclamation point, are not accessible?
Boy, you know, for me, it's a rough thing. And this is kind of like being a Republican as a creative, right? You just don't really go out wearing that flag on your sleeve as you walk through Adobe Max or whatever. But I have encountered many situations where an overlay was not a significant barrier. The problem is there's no blanket. The large majority of them do have barriers, and it's only when using assistive technology and only when trying to navigate through some of these, you know, menus. You know, Jason, you talked about these menus. Usually it's a little icon. You can focus to that icon, pop up the icon, but usually what it is the interface itself has got some keyboard trap or something pops up and you have no way to know what you're affecting. And I think that's the large majority of where those overlays fall short. The other ones that I think are interesting, and Jason, you can weigh in on this, is the ones that say, we'll write the alt text. It'll automatically figure out what the alt text is for your images and make sure that nothing is without alt text. And I think that's the biggest gap.
Well, I mean, let me try to explain how these quote unquote widgets, you call them overlays, but I call them widgets because most of the time they're sort of affecting the interface in front of you. Okay?
Sure.
How they work and how they're not doing accessibility. What they are doing is exposing to the user, typically unaware users, that there's actually controls inside of your browser that allow you to have a more accessible experience.
Right.
So, for example, increase the font size, right? But the font size has to be the font has to be coded in a way to allow that font size to be expanded, right? So if I put it in the document world, imagine you're a novice PDF user and you didn't know there was a search on PDF. You didn't know that there was a command on PDF to increase the font size, right? To read it. So I came along and I created a widget in front of there, which had like big buttons that sort of like introduce you to the idea that you can increase the font size, you can search for things, you can actually list the headers, right?
Right.
Well, if the PDF doesn't include headers, it won't list the headers. If
Right.
the PDF is a locked image that doesn't allow you to expand the font, it doesn't expand the font. So essentially what widgets do is they actually look good on a site that's accessible. They're terrible on a site that's not accessible.
Gotcha.
They're not actually changing the accessibility of the quote unquote document, which is HTML underneath. So that's the way I would describe it to your listeners who understand PDF. It's like, well, if you made a PDF inaccessible, but you like wanted to use some features like search, but it was actually a scanned image, you wouldn't be able to find anything, right?
Right.
So it's like that. These widgets essentially help you use a site and use features of browsers that already exist to most of us who understand how browsers work. But a lot of people don't know these things exist. A lot of old users who use website for the first time didn't know that they could increase their font size easily. It's not obvious to them, right? It's not.
Right.
And they see a widget like that and they're like, oh, look, help me increase the font size. And actually that's good. That's not a bad thing to that particular user. but it's not fixing the accessibility code. It is not fixing the HTML doc underneath. That's the big difference.
Well, and there's a lot of times where I use Control Alt and the scroll wheel on my mouse in a browser. And that immediately increases everything, font size of everything, right? It's the zoom, it's Chrome's zoom, right? But there have been lots of times where I'll go to a website, I'll zoom in and everything breaks. The layout completely changes and it doesn't maintain that kind of flow that it maintained before. And I think that's a lot of the big problem too. If I'm a low vision user, maybe not necessarily a screen reader user, I need that site to stay structured the way it's supposed to look, at least so I know where to go.
It's a great example of what the widget does is expose the alt scroll functionality to a user that doesn't know that exists. So if the website's actually accessible, that's actually going to look quite good.
Yeah.
But if the website isn't accessible, it's going to break. It hasn't fixed the underlying code.
So Chad, you and I were looking at the report, and there's this one slide in here that says, talks about companies making more than $50 million annually and less than, right? And I think, you and I on the Facebook group, we get a lot of people asking, when do I start caring about accessibility, right?
Yeah, absolutely. I mean, and I think the answer is, and this is where, Jason, you said something earlier about, people will bring up these lawsuits under the ADA, the law. And, Dax, you and I have talked about this, how unlike Ontario, right, which has made accessibility a legal obligation to public and private industries, the U.S. has not done so, right? At least not officially, right? At least
it's waffled. It's waffled back and forth for sure. And Jason, you could talk about this. There's lawsuits, right? Some of them say, yes, you're at fault, and others say, no, you're not. It seems like every time I turn around, that's going back and forth. Yeah.
Well, it reflects what you said about where the cases are mostly taken, right? Most of the cases are taken in New York and California because those courts allow a website to be sued under the ADA. Most of the other circuits don't allow a website to be sued under the ADA because websites aren't explicitly written as a mechanism inside the ADA, which was written 30 years ago. But early on in this process, you can go back. The DOJs for 20 years has said websites count, right? New York judges have listened to that from plaintiff firms and say, well, if the DOJ says it counts, then it counts. That's their general sort of position. Other circuits have said, well, I don't care what the DOJ says. Like Texas says, I don't care what the DOJ says about many things, right? Unless it's written in the law, it's in the law. So, and that's why you'll see that sort of concentration in California and New York. Not only that, they have state laws. So there's sort of, you can get hit twice. You can be like, hey, you broke the state law and you broke the ADA law, and essentially that gives a plaintiff a lot more to negotiate with. Most of these cases do not go to trial. Most of these cases essentially settle out of court. I'd say 98% settle out of court. And they settle quickly because the only remedy, the only damages you can get essentially are lawyer fees, and you have to remediate the site. So if you let the plaintiff firm talk for days and hours, the fees are going to get higher. So essentially, people quickly determine, hey, did we do anything? Did we do much? If we didn't, we're not going to be able to defend this. So let's settle and let's fix the site. So that's sort of the general activity. But again, in the overview of accessibility, that's quite a good outcome. But I feel very sorry for the small companies, which you were talking about. Ma and Pa, who's got a website, they brought that website off of somebody for a couple of $100 or $1,000. They never knew about web accessibility. They could be sued and have to pay $10,000 damages on a website that only cost them $200. And that's sort of my big peeve is like how the CMS guys are getting away with delivering these websites, which are essentially inaccessible, but they're not responsible for them because under the ADA, you're responsible for the website that you purchased, not the person that built it.
Well, to be fair, I think, I think there's a lot of folks out there who learn WordPress, they learn Joomla, Drupal, whatever it is, and they're like, hey, I could build you a website. And they literally know nothing about web accessibility, right? I mean, they're still kind of in that mindset of, hey, I'm just going to deliver this visual masterpiece, if you will, to my client who loves it. They love how it looks, but that they really don't understand what web accessibility even is. I mean, I've talked to a lot of web developers. When I mention accessibility, they're like, what's that? So
Yeah. So
yeah.
Well, I'd actually say it actually multiplies when you start building a complicated site.
Sure.
Right.
It
Well,
doesn't-
when
it doesn't get the guys don't have less to learn. They have more to learn, and accessibility is the last thing on the list to learn. If you're building a dynamic, interactive banking site, accessibility is not on the curricula. You know what I mean?
Well, I actually, bring this up on more than a few occasions. Capital One, I had taken my keyboard or I'd taken my mouse and put it in my bag, left, but then I got a pop up on my phone saying I needed to pay my credit card bill. So I'm like, crap. So I tried to use my phone. I didn't remember the login. So I had to go back to my computer because the login's already pre-populated, but I didn't have a mouse. So I had to use my keyboard only to get in to pay the bill right before I left on a trip. And I went in and I'm trying to navigate, tab, go to the thing, type my username, password, hit enter, and nothing. Like, okay. And then I had to go in a different way. I had to find it. There was another pay now button. And when you click that, it was able to let you log in and then pay. So it was interesting, even on the popular sites. I mean, even on sites that are, multi-million dollar, billions of dollars, Capital One, right? There's still those issues. And, we had somebody reached out to me on our Facebook group, and she was a veterinarian, and said, hey, when do I need to make my handouts that I'm giving to people accessible? Is it required? I said, well, I think if I knew that I had people with low vision who are pet owners, or I had people who are blind that needed to take care of their animals, absolutely. She said, but what's the legal obligation? I said, well, it's interesting because the Unruh Act says that it provides for equal accommodations and advantages, facilities, privileges, or services in all business establishments. And then there's several different things that it lists, but a vet hospital is a business establishment, and you could connect the dots and say, well, if you're providing a service, the stuff that you're providing should be accessible. And so there's a way to get there. But like you said, I feel bad about the smaller organizations, the mom and pops that really don't understand what this is. And in California, we have the Unruh Act, but I'm sure that there are other states that have similar legislation that kind of connect these dots.
Yeah, I mean, New York has similar, but actually, if you think about it, digital can be the answer to lots of these questions, right? Because if you said, actually, we're not going to do physical handouts, we're going to do PDFs, which are accessible. Well, now everybody's getting what they need.
Right.
We're also not, cutting down trees to do it, right? And you deliver. It's why. It's so. For example, like when companies started to talk about Braille discount cards in stores, right? The real answer is to make sure that that the cards are actually available digital, so you can actually access them digitally, use them digitally, right? Because that actually helps everybody, and it's really, there's an argument that digital, yes, there's things to do, but actually, if you do digital right, you solve all the other problems in the non-digital space. So, for us, digital accessibility, if you start out with that in mind, you can actually reduce costs and reduce the things you need to do on the accommodation side if you do digital in the right way.
Well, that's a really interesting point, Jason, because let's say it's a company, and they're like, you know what, I'm not into this whole digital stuff. I'm just going to print out a bunch of handouts and provide them to my customers, right? Which obviously are completely inaccessible to a certain part of the population. I mean, is that a concern, right? I mean,
It's not my area of expertise, but the requirement of accommodation has been there for a long time. So to accommodate someone could
right.
be that you say, look, if you can't read this, we'll read it for you. That's accommodation. That's absolutely fine in a scenario, right? But again, the problem that what digital can give you is privacy. It can give you other things that you can't get.
Independence, for sure.
Independence, privacy. This is why, it's short-sighted to think about moving away from digital because of accessibility. It's actually empowering to organizations and empowering to the individuals. That's one of the biggest issues with anything to do with security and privacy and independence. It's all sort of combined.
On our Facebook group, we had someone. I keep mentioning the Facebook group. I feel like this is a commercial for the Facebook group. This podcast, it's not done on purpose. But on our Facebook group, one of our users had chimed in and said, "Well, we need a wet signature on this form. We need an actual hand signature." And one of our blind users actually chimed in and said, "Why? A digital signature is just as valid.
Right?
And I don't have to go get someone, bring them to my house." Disclose whatever document this is so they can figure out where I'm supposed to sign it and then direct me on where I'm supposed to wet sign it, as opposed to just clicking a button that has my digital signature in it, right?
Listen, I firmly believe that that's an educational problem, right?
Yep.
And I experienced this firsthand. I had to fill out a form when I was having some work done to my house. And I it was not a fillable form. It's just a form, but they gave it to me in a PDF format. So I have a PDF signature that I use. It's a beautiful vector signature that I could just plop in whenever I need it. I submitted the form and they rejected it.
I've had that happen too.
Because the signature was too good.
Yep.
Because they could not clearly see that I didn't print it out and rescan it back in. They rejected it.
Yep.
Now, how asinine is that? Right. Yeah. And again, keep in mind that a non-sighted user would not be able to do that. Let's totally ignore that fact. Right. But I can't tell you how many times, I've been doing forms for clients and I'm like, well, there's no fillable fields in this. They're like, that's okay. I'm like, well, no, it's not, and they're like, no. They could just have somebody print it out and fill it out for them. And I'm like,
you could use fill-in sign, right? I've heard this too. Well, you can just use fill-in sign to figure it out. I'm like, yeah, you have to click on fill-in sign. It is a 100% mouse activity where you just have to be able to know where you're supposed to click and put that stuff in there. I just filled out a form for a large health organization that you know very well, Chad, where that was the case. It was an intake form for something. And I was like, wow.
It's an interesting subject that I get into when people talk about these lawsuits and how the law needs to change to make it simpler for people to understand what they need to do, right? And make sure everyone does it. Well, we had that with Section 508, and most government websites are still inaccessible. So,
that new thing, right? That new thing, Section 508.
Yeah,
right?
I'm just saying
all the time.
The reality could be that if you made this law, there'd be more lawsuits,
right?
Because it's actually, if a law said, hey, what might be a really good thing about the law is that certain size companies might be sort of given a safe harbor or some more time to deal with it because of the cost factor, right? But most of the advocates don't want that. They're like, well, it's been around long enough. You shouldn't be given 2 years to fix your website. For me to use my banking site, I'm going to give you 2 years. That doesn't make any sense.
Right.
But if the law says, websites have to be WCA 2.0 AA conforming, well, one missing alt tag a lawyer could use as a saying that you're not there. So depending on how the law's written, a law might actually increase lawsuits rather than decrease lawsuits. Just to be, to be frank about when people are like, we need the law to be clearer. Well, unfortunately, most of the laws out there aren't being followed. If Section 508 is not, there's no teeth in it, but lawsuits do focus the mind of big companies because they want these lawsuits to go away.
Well, they
Right.
do what they have to, right?
Yeah.
What is we have clients that will tell us what is the minimum I can do to mitigate my risk.
Yeah.
And, we'd love that everybody would just do the right thing. But, and honestly, if everybody just did the right thing most of the time, you're going to, some accessibility is better than no accessibility.
Yeah.
You can go in and say, look, my site is 95% accessible. We missed this one image we posted on a page 3 days ago or last month or whatever. We'll go back and add that.
I have a slightly different, I use, this is why we use this data from this report for our clients, right? Because if you want to prioritize what to work on, I say prioritize on the things that plaintiff firms are looking for.
Right.
Because it will make your site more accessible and it will reduce your risk.
Yep.
That means going and get a blind user, because most of these lawsuits are taken by the blind. Get a blind user to use your site and tell them whether they can achieve all the things you expect them to achieve on a site. And if they can't, fix it so they can. Right? That's a great place to start. Simple. Practical, right? Run these automatic tools like Wave and stuff on all the top pages, and all this stuff is easy to find and pretty easy to fix. Fix it all.
Yeah.
Right? Those two things will reduce you, because that's all the plaintiff firms are doing. They're not spending days looking at websites; they're spending a couple of hours. So if you focus on those things that they're doing as your priority, as part of your sort of roadmap, you will reduce your risk in getting lawsuits, and it's a practical step to go.
Well, Dax, you and I have said multiple times where we've created this scenario and we'll say, well, you're not going to get sued for missing alt text on an image. And, we need to be careful about saying that, right? Because we're not attorneys, right? We have no legal knowledge whatsoever. But I think you are right. You know what I mean? You're going to get sued for gross violations, violations that are preventing you from getting to the information. Right.
Well, it really goes back to providing damages. I had a horrible accident when I was younger, in my 20s. I worked on an oil field on a oil rig, and we had the cables broke. Everything fell. The cables almost crushed me, threw me off a deck 15 feet. I had a big bruise on my shoulder, and I literally missed dying by just millimeters. And I went to a lawyer. I'm like, okay, they knew the cable was frayed. They knew all this stuff. And the answer was, well, Dax, you don't have a whole lot of damages. You have a bruise. And so there's really no lawsuit there. So I think the same thing kind of falls with a lot of these, some of these accessibility lawsuits, where you have to show damages or show that that there's a barrier to information. And Jason, maybe I'm wrong, and you tell me if I am, but it seems like you're not going to get sued because you didn't follow 1.3.2. You get sued because I went on the website, I was looking for directions to get to your store, or I wanted to purchase something and I couldn't, and therefore I don't have equal access and it caused me damages. Would you say that's correct?
Partly.
Okay.
Partly.
And like Chad said, I'm no lawyer, so that's for sure.
Partly is these law firms are going to run a scan on your website.
Okay.
And if they find lots of things, they're going to list them in the website, in the lawsuit.
Gotcha.
Then they're going to ask their blind plaintiff to go in and find a couple of things that they can take screenshots of that they had issues with, and that makes you a lawsuit. So
there you go. It's a lot easier than what I'm making it out to be.
Yeah. There needs to be enough for the conversation to have to carry on, because the plaintiff firms want fees, essentially. So, they want to make it hard for you to say, hey, these things don't exist.
Right.
And if they exist, then they know that basically you're going to settle, because your arguments are valid, but it's going to cost you $20,000, $30,000 to get in front of a judge. So right. if I'm a plaintiff and I say, we'll settle for $10,000, you're going to settle for $10,000 rather than spend $30,000 to get in front of a judge and argue that you did a good job.
Right.
So
that makes sense.
You want to make sure that you're sort of out of the hot, but the sweet spot for them to actually find you. Find a lot of issues on your site, because that essentially will help you protect yourself.
So we've been talking about this report throughout the podcast. Jason, how can our users get a copy of the report?
Super simple. UsableNet is the company I work for. That's UsableNet.com. Okay. And if you go to the homepage, right on the homepage, you're going to see download the free report. And essentially, the report is free. As Dax said, it comes as a PDF, accessible PDF, but also it comes as a transcript. So, it's available in many formats.
Awesome. So to our listeners, I highly encourage you guys go onto the UsableNet website and download this report. At the very least, it's just really interesting to kind of see like where these lawsuits are coming from, who's affected, and just it's not very long either. We call it a report, but what is it, about 10 pages? I have it open in my browser right now, but it's
around about 10 sort of like 10 key data points, which I think, as you say, I think people will find this interesting, and understand what's driving sort of this particular sort of private lawsuit space.
For sure. Well, Jason, thank you so much for joining us today and being our guest. Really a lot of great information that you shared with us, and we look forward to having you back again in the future.
You're welcome, guys. Thanks again for having me.
All right, guys. So once again, we want to thank Chelius Training and Consulting for sponsoring this episode of the podcast. And just remember, if you're looking for in-person or online training, or just struggling to establish an accessibility program within your organization, head on over to accessibilityunraveled.com to learn more. My name is Chad Chelius.
And my name is Dax Castro, where each week we unravel accessibility for you.
Thanks, guys.